Welcome, everybody. This is our second pre-hearing conference in docket 9818 CE 100, the application for a CPCN of Ursa Solar to construct the Langdon Mills Solar Electric Facility. This is Mike Newmark, Administrative Law Judge for the PSC. And let's just do appearances on the record. Who do we have from the applicant?
Eric Callisto, Michael Beston Friedrich.
Okay, and for intervener Ton.
I'm here representing myself, Lauren Ton.
Okay, Renew Wisconsin.
Michael Vickerman, Renew Wisconsin.
Okay, I see Andrew Kell there as well. And also for Clean Wisconsin, our potential intervener at this point.
Good afternoon, Your Honor. This is Brett Cordy on behalf of Clean Wisconsin.
All right. Oh, and the commission, of course, commission staff.
This is Kara Kuntz, Assistant General Counsel for the Public Service Commission.
Okay, thank you. I saw you there and I'm wondering why are you staring at me? All right. So we're here. We do have a intervention request that's an out-of-time request from Clean Wisconsin, and we did receive a objection to that request and a number of filings related to that response from we received a response from the applicant and intervener Ton, and a reply from Clean Wisconsin. So with that, I had a few questions after reading through the documents that I thought I should clarify, get some clarification for. And at that point, kind of derailed my process of deciding in a written order because I just couldn't really get as far as I thought I could. So it would be beneficial to bring everyone together and get just some answers to those questions. And in the email where I called for the pre-hearing conference, I did include, I think, just about all those questions. I may have one more additional question to ask, but just wanted everyone to be prepared for this. But before we get into that discussion, I did want to preface this with a little disclaimer because it's pretty rare when we have opposition to intervention requests. Typically, you see that an order on request to intervene usually is a one-liner. It just says, I am approving the undisputed request to intervene of, and then I just list those entities. And I just wanted to be clear the distinction between when there's an undisputed request and the process for review and approval of that versus a contested or disputed request. So just wanted to go into that little side here first. So to process a request to intervene, the commission relies primarily on the adversarial process to reveal any legal and factual deficiencies a request may harbor. Parties rarely challenge a request to intervene. Therefore, the commission grants the overwhelming majority of requests on the basis of the tacit acceptance of the existing parties. Furthermore, the order granting intervention remains silent with respect to the application of the standards for intervention to the request. Overall, this open door policy towards intervention benefits the record that the commission must use to form the basis of a decision in each proceeding. This policy allows the commission to hear from all persons who perceive an interest in the outcome of a proceeding by providing them an equal opportunity to present their perspectives, facts, and analysis to the issues presented. Any decision rendered today affects nothing with respect to that general process and practice. While granting an undisputed request to intervene does not require the commission to closely scrutinize the request, upon a challenge, the commission must analyze the request according to the Wisconsin Administrative Code, Section PSC 2.21 standards for intervention by right, permission, and if applicable, intervention out of time. So that's where we stand here today. We're processing a contested request to intervene. And so, in processing that, I ran into the first hurdle which was that Clean Wisconsin and the applicant both rely on the standards for determining intervention by right as articulated in the following case, Wisconsin Environmental Decade versus Public Service Commission. And so I'll just say the citation once here. It's 69 Wis 2nd 1 from 1975. And I think it's usually referred to as WED 1. So because the citations I saw in the briefs, because the arguments I saw in these briefs relied on that citation, I was interested to know, there's a more recent case. It just came out in last June. It's the Friends of Black River Forest versus Kohler Company. And that citation is 2002 WI 52. So I was curious to hear whether parties or staff had an opinion on whether the decision in Friends of Black River Forest affected the standard we're applying for this request to intervene in any substantive way. And I probably want to hear from Clean Wisconsin first, if you're prepared to do that.
Yeah, thank you, Your Honor. So I'll start by explaining that our reliance on Wisconsin's Environmental Decade, which is applicable to standing inquiries on judicial review of administrative decisions, which of course is a little bit stricter than the standard applicable here because there has been no agency action as of yet. Reliance on that case is for the proposition that an organization has standing when a member of that organization may have standing in their own name. So Your Honor instructed us to explain any implications of the Friends of the Black River Forest v. Kohler Company standard case on that standard. In that case, the Supreme Court clarified Wisconsin's two-prong standing inquiry for judicial review of administrative decisions. The court maintained the first prong that the challenged action will cause a petitioner injury in fact, but clarified the second prong, and this is where it moved away from the WED court's zone of interest inquiry. Instead, the Supreme Court now requires petitioners to identify a statute which protects, recognizes, or regulates an interest the petitioner alleges has been adversely affected, and that's from Friends of Black River Forest at paragraph 46. As for statutorily recognized interests in this proceeding, Clean Wisconsin's interest in environmental protection afforded by the applicable regulatory requirements suffice. So these include the Commission's compliance with Wisconsin Statute 1.12, the Energy Priorities Law, which prioritizes renewable resources over fossil fuel resources, the public interest considerations, including environmental factors under 196.491 3D3, and the environmental impact assessment requirements of Wisconsin Administrative Code PSC Chapter 4.
Okay, thanks. So did the applicant want to comment on that question too?
Sorry, just briefly, Your Honor, I agree with Clean Wisconsin's analysis. I'd note as well, I think that from a statutory perspective, I would imagine there's an interest here from Clean Wisconsin in compliance with the RPS statute 196.378, which has relevance to their core issues about concern about air and water. And I know that council represented 491.3D3. I think also 491.3D6 is relevant. And this gets to the very specific issue of the relevance of the document they intend to introduce through a witness on the comparison of use of land for ethanol production versus solar. That particular statute that I cited is the Commission's obligation to find that the project does not unreasonably interfere with local land use. So I think that's also a core Commission finding requirement in this case that Clean Wisconsin has an interest in promoting.
And does Renew Wisconsin have an opinion on this?
At this point, we don't have, we're not represented by an attorney, and so we cannot comment on the legal arguments that are being presented here. And I must keep my conversation brief as I'm in the middle of a very busy Dallas-Fort Worth airport.
Okay, well, thanks for giving us that warning there. Yeah, and I guess I'm not going, I'll hear from anyone representing a party at this point. I know that one party, certain parties don't have legal representation, but I'm open to hear an argument about that. So let's continue on with intervener Tan. Any opinion on the effective Friends of Black River Forest?
Well, I can't say that I'm as educated in that Supreme Court finding as the other two attorneys here today. But what concerns me is that Clean Wisconsin is saying that they have a right to intervene because they have members throughout the state of Wisconsin that this would affect. However, two individuals who had tried to intervene and actually live within the project area, receive mailings from the project, were not allowed to intervene, even though they have what I would consider a more substantial case than Clean Wisconsin. They live and work in this area.
I'm going to stop you there just because I'm just focusing on the Friends of Black River Forest right now, but I understand where you're going on that. So any comment from commission staff?
I don't have anything to add this time.
Okay. All right. Okay. Thanks. So, so what I'm hearing, I mean, my general opinion was basically that maybe I was mistaken about how to apply WED1, but basically I'd always been doing exactly what it seems to be the prescription in Black River Forest, which is to find the statute that has the legally protected interest, that the statute that the law seeks to protect is something that needs to be asserted. And I think that's how we've been processing contested intervention requests since I started practice at the commission. Maybe we were doing something that maybe we're missing something, but my impression is that it doesn't seem to change. Black River Forest doesn't seem to change our practice in terms of looking at what's needs to be asserted and how the standards apply to requests to intervene. But it sounds like we have consensus on that. I don't think I've heard that there's been a major shift here with this most recent decision. Do people agree with that?
This is Eric Calistiano. I do agree. I think the court focused on eliminating effectively the zone of interest, but then it turned very directly in that case to the statutes. And I think we've provided statutes on the same basis here.
Okay. So let's proceed with that. So I think I basically will be following I never really used the zone of interest consideration when applying the test that's provided in WED1. So I think it's safe to use my existing practice, and it does revert back to looking at the WED1 case. So So I did have another question regarding the right to intervene, another clarifying question here. So in the past solar project CPC on dockets where Clean Wisconsin has intervened, Clean Wisconsin asserted that a number of its members, I'm quoting here, live or work in the area and will be affected by decisions made in this proceeding. And for example, that language appears in the request to intervene by Clean Wisconsin in docket 19815 CE 100. And I looked at their request for going back a number of years, and there is this similar language. So I'm curious, first of all, to explain the consequences of Clean Wisconsin's failure to make that assertion in the instant request. Go ahead, Clean Wisconsin.
Thank you, Your Honor. So Friends of Black River Forest affirmed the allegations and petitions are entitled to a liberal construction in favor of the petitioners. That's at Friends of Black River Forest, paragraph 11. In our request and intervention in this docket, we did assert that Clean Wisconsin members will be affected by decisions made in this proceeding. And though it was not explicit in our request for intervention, Clean Wisconsin has over 370 households in Columbia County, each having at least one member of the organization in that household. This also includes at least 9 households with Cambria addresses. And to the best that I'm able to calculate, based on the applicant's project map, we have at least one household within 1,500 feet of the proposed project. Clean Wisconsin's interests as an organization on behalf of our members include the protection of air and water resources and advocating for clean energy. Our members, both in proximity to the project area and across the state, have an interest in responsible siting of energy resources and the generation of renewable energy in Wisconsin. But I wanted to highlight those specific members today for your convenience.
Okay, so the member within 1,500 feet of the project, where would we find that person on the project map? Do you know?
So we don't release any of our member information publicly. I would be prepared to give you a name and address in camera if that's something you'd like.
Yeah, why don't we do that? So we'll need to go into a breakout room. So I'm going to set that up. And you're going to have to disclose this to at least the people in the hearing. And
That would be something we would rather do with an NDA in place.
okay, so let's forgo that then. So so we have an assertion anyway that there is a Clean Wisconsin member within 1,500 feet of the project. Okay.
And another one certainly within the mile radius, but probably around based on the applicant's maps, I think it was around 3,500 feet from the project.
Okay, and so I'm just curious when it comes to where you assert a member, you have members in the project area. That was in the Clean Wisconsin reply.
No, we didn't raise that yet, Your Honor. I mean, our position is that our statewide mission and the interests of members statewide are impacted. But to the extent that you're looking for a specific proximity to the project, I wanted to be able to provide that to you today.
Okay, thanks. Okay. So let me get so let me finish up with Clean Wisconsin. Then the second question here is explain the consequences of Clean Wisconsin's failure to assert how a member in the project area how a member in the area of the proposed project may be affected by a decision in this proceeding.
Again, Your Honor, I kind of covered that in my last response. I just, any allegations, and this is making an analogy with a petition for review, but any allegations would be liberally construed in our favor. We did assert that we have members that would be affected by the decisions made in this proceeding. So that's my response to that.
Okay. So you have alluded to a distinction between processing a petition for review, for judicial review, and this proceeding here, this processing a right to intervene. And can you elaborate a little bit on what you think how the standards differ?
Well, just in the fact that when you look at, the analogies of the substantial interest that may be affected in the PSC intervention regulations is interpreted as meeting the standards for, the standing standards in judicial review.
And that would be compared to what would be the other standard we're talking about? I don't.
They may maybe differences without distinctions, just that the intervention the statute providing for intervention also talks about substantial interest, which has been interpreted by courts to then mean what the exact thing that they say about standing in judicial review cases.
Right. So I'm proceeding under the WED1 standards in order to process the right to intervene in a commission proceeding. Do you have any, do you take issue with that?
No.
Okay, all right. Okay, so let's move on to the applicant. Any comments on the last two questions? Explain the consequences of Clean Wisconsin's failure to make the assertion that members live and work in the area affected, and explain the consequences of Clean Wisconsin's failure to assert how a member in the area may be affected by a decision.
Your Honor, and I think I'll just briefly echo what Clean Wisconsin said. To the extent the court sees their initial failure to plead members in the area, I think they've cured that by counsel's representation as an officer of the court. I also support Clean Wisconsin's view that because of the statewide interest of both their organization and the nexus of that with projects like this that have a statewide interest, right? By design, a CPCN size project is before the commission because it's a project of statewide interest. I think they have standing on that basis also.
Okay. So I'll just run through the list here. Any opinions from Renew? No. Commission staff?
No.
And Lauren Tom?
I would just say, Your Honor, that with them not even stating that in their initial request, that it leads me to believe that that wasn't even something they were considering when applying to intervene. I don't think they even knew what members they had in this area until that was brought up in my objection. I would also be interested to note if those members that are what they deem close to the project area have asked them to intervene on their behalf in this. That would be, if they're coming in as an organization stating that they're standing up for their members' rights, have those members even acknowledged the project or asked to be intervened on their behalf?
Okay. All right. Well, thanks. So I think I'm prepared to rule on the right to intervene. And so I don't think I'll need to change what I have written here very much. It's quite long, so buckle up. But I do want to decide this here today, if possible. So the right to intervene follows the same legal standard as the right to petition for a judicial review of a commission decision. The standard for the right to petition for review is expressed in WED1. Procedural, this standard treats a challenge to a petition for review as a motion to dismiss for failure to state a claim, i.e. whether a petition on its face states facts sufficient to show that the petitioner named therein is aggrieved and directly affected by the decision sought to be reviewed. And that's page 8 at WED1. As the normal rules for standing apply, analysis of the petition includes the allegations of the petition are assumed to be true. The allegations are entitled to a liberal construction in favor of the petitioner and not concerned with the ability of the petitioner to prove the facts alleged at trial. It's WED1 at 8 through 9. While this motion to dismiss process is how the commission determines an objection to a request to intervene, in WED1, the process continued on remand to the circuit court to determine whether the claims of Wisconsin Environmental Decade, the petitioner in that case, were true. So we're not going through that process. Substantively, this process follows a two-step analysis to first ascertain whether the decision of the agency directly causes injury to the interest of the petitioner, and second, determine whether the interest asserted is recognized by law. That's WED1 at 10. In other words, this two-step analysis requires that to have standing, the petitioner demonstrate both that it sustained or will sustain, in our case, the alleged injury, or may sustain, let's say, may sustain the alleged injury due to the agency decision, and that the injury is to an interest which the law recognizes or seeks to regulate or protect. That's actually from Waste Management of Wisconsin at 505. An injury alleged which is remote in time or which will only occur as the end result of a sequence of events set in motion by the agency action challenged, can be a sufficiently direct result of the agency's decision to serve as a basis for standing. WED1 at 14. The magnitude of the injury is not determinative of standing, but the injury alleged must be real and immediate, not conjectural or hypothetical. And that's a case, the Fox case at 525. WED1 is instructive because Wisconsin Environmental Decade asserted 3 grounds for standing, and the court accepted one and rejected the other 2. WED1 arose during a period of natural gas supply shortage, and a commission order that Wisconsin Public Service Corporation moved from an overall curtailment of gas service set in a previous order to an arguably less restrictive priority system for gas sales. WED1 at 4 through 5. First, the Wisconsin Environmental Decade petition asserted that 3 of its members were pub service customers, and that the order, by raising limits for natural gas use, would prematurely devour natural gas reserves, preventing future availability. That's WED1 at 13. Wisconsin Environmental Decade also contended that the asserted interest in the conservation of natural gas let me say it again. Wisconsin Environmental Decade also contended that an asserted interest in conservation of natural gas so that it will be available for future users is a legally recognized interest under various provisions of Chapter 196. That's WED1 at 15. The court in WED1 agreed, granting standing to Wisconsin Environmental Decade by stating that our conclusion is that Wisconsin Environmental Decade's members who are customers in the area affected by the PSC's order in this case have a sufficient interest under the cited sections of Chapter 196 in the future adequacy of their service, and that Wisconsin Environmental Decade has standing, if the facts alleged in the petition are true, to challenge the PSC's failure to consider conservation alternatives to the proposed priority system. It's at page 17. Then WED1 adopted the following rationale for allowing organizations to petition for review. An organization devoted to the protection and preservation of the environment has standing to sue in its own name if it alleges facts sufficient to show that a member of the organization would have standing to bring the action in his own name. Wisconsin WED1 at 20. Second, the Wisconsin Environmental Decade petition asserted that the order, by inducing lower priority customers to rely on more environmentally damaging sources of fuel, it asserted an injury, that the order induced lower priority customers to rely on more environmentally damaging sources of fuel. That's WED1 at 13. The court then explained, the petitioner then explained outside the petition that promoting the use of dirty fuels will damage navigable waterways protected by the public trust doctrine. The court rejected that ground because the petition does not raise the issue on its face. The public trust doctrine is unavailable as a basis for standing. WED1 concluded that we are unwilling to adopt a rule that any allegation of harm to the environment raises by implication an allegation of harm to navigable waterways. That's WED 1 at 15. Third, the Wisconsin Environmental Decade petition alleged that the order would encourage environmentally destructive practices such as strip mining. WED 1 quickly rejected that claim, stating that there's nothing in the allegations from which it could be inferred that the petitioner or its members would be injured by such activity. And that's on page 15, footnote 23. In addition to these claims, Wisconsin Environmental Decade contended that the Wisconsin Environmental Protection Act, WEPA, recognizes the interests asserted with regard to the protection of the environment from the harmful effects of burning fuels other than natural gas. The petitioner, as the court stated, the petitioner would have this court hold that WEPA establishes a new public trust in the entire environment. WED 1 at 16. The court rejected the concept that WEPA created public trust in the environment, but stated that persons may petition for review to question an agency's compliance with the WEPA process, where it is alleged that the agency's actions will harm the environment in the area where the person resides. And that's WED 1 at 19. So I believe that the request fails to demonstrate Clean Wisconsin's right to intervene. The request's silence with respect to the essential elements of standing speak volumes. As far as its members being affected by a decision in this proceeding, the request does no more than make the conclusionary statement: Clean Wisconsin members will be affected by the decision made in this proceeding. That's request at 1. The request then cites the rationale established in WED 1 that allowed an organization to stand in the shoes of its members. Those members would otherwise have standing. However, no resemblance exists between this attempt to establish a right to intervene and a petition that on its face states facts sufficient to show that the petition named therein is aggrieved and directly affected by the decision sought to be reviewed. The Clean Wisconsin reply adds a further rationale to the request that Clean Wisconsin meets the standard for intervention by right because it is a nonprofit organization that advocates on behalf of its members for clean air, water, and energy. The organization has over 20,000 members and supporters statewide. Clean Wisconsin's substantial interest in protecting Wisconsin's air and water resources will be affected by the Commission's decision in this proceeding. This claim to standing has no legal basis. As exclaimed in WED 1, the law does not recognize a public trust in the environment. Claiming a generalized interest in protecting the environment without asserting an injury to a substantial interest that the law seeks to regulate or protect of a person who resides in the area of the project fails the test for standing and therefore cannot form the basis of a right to intervene. So let's move on to permissive intervention. The Commission may allow permissive intervention if the person's participation will likely promote the proper disposition of the issues to be determined in the proceeding or docket, and if the person's participation will not impede the timely completion of the proceeding or docket. And that's Wissadmin Code, Section PSE 2.21, Sub 2. The request asserts that Clean Wisconsin seeks intervention for the sole purpose of introducing a study entitled, this is the title of the study, Corn Ethanol versus Solar Land Use Comparison. We'll call it the study going forward. The request argues that the study will promote the proper disposition of the issues to be determined in this proceeding by addressing concerns raised by intervener Kahn with respect to the impacts of removing agricultural land from production. That's in Clean Wisconsin's reply at 4. So the next question that I would like clarification is explain the extent to which the impacts of removing agricultural land from production are an issue in this proceeding. To address this question include the CPCN standard, which the study will promote the proper disposition. Go ahead, Attorney Courtland.
Thank you, Your Honor. This is the exact provision that counsel for applicants pointed to earlier in this hearing, Wisconsin statute 196.491 3D6 requires the commission to determine that, quote, the proposed project will not unreasonably interfere with the orderly land use and development plans for the area involved. And indeed, in her request for intervention, intervener Tone raises, among other issues, the lack of food production, impacts on agricultural-based businesses in her community, and loss of USDA classified prime farmland. To the extent parties or the public raise issues concerning the use of land currently under agricultural production for renewable energy generation, our study directly addresses these concerns.
So as a follow-up question for Clean Wisconsin, how will the project affect the transition from fossil fuel transportation to transportation fueled by non-combustible renewables?
The purpose of introducing the study in this proceeding is to address those concerns about land use that are relevant to the statute I cited. So with intervener Tone raising her issues in the request for intervention, those are on top of having it, as part of the CPCN statute requirement, something for the commission to consider. It's been raised by another intervener in this case. So the point of the study, one of the points of the study is to discuss how land use is currently being used for energy production. Agricultural land is currently being used for energy production in the form of ethanol. We think this is a relevant consideration if the commission is to consider those impacts on agricultural use of land.
Okay. But the issue of land use, agricultural versus, well, let's say agriculture for crops versus agricultural for electricity, is that a choice the commission is making in this case?
To the extent that they would consider the land use under 196.491 3D6, and again, based on the stated interests of intervener Tone in this proceeding, we have information that we believe is relevant to the commission's consideration of those issues.
Okay, so let's hear from the applicant. Did you have anything to add on those questions?
Yeah, perhaps maybe a little color commentary, Your Honor. I do point to the application table 5.3.1-1, where we note that 82.5% of the project is ag land, right? So this is a project that is temporarily converting ag land from traditional ag use, and I don't know whether it's being used for ethanol, corn ethanol production or not at this point, but it is certainly being converted if the CPCN is granted from ag use to a form of energy use. I think it's beyond debate. I mean, Ms. Tan has put this issue squarely in front of us in her request to intervene about the conversion of ag land. And so I have been at public meetings, as has Ms. Tan, the Columbia County Board, where it was a front and center issue from many of the apparent opponents to the project. So I do think that land use is an issue. I think, as council noted, 491 3D6 requires the commission to look at local land use plans and make a determination that this project will not unreasonably interfere with them. That includes looking at comprehensive land use plans as well as zoning codes. And so land use is front and center. And then the fine point that we have in front of us here based upon this report is, if we're going to talk about land use, do we have a fuller discussion of the topic if we have an honest analysis of what land in Wisconsin is being used for now? And I think, as I understand the report, it suggests through its analysis that land is being used to produce ethanol. and that based upon their analysis, it's a much more effective use for the generation of energy to use solar production and use that as a way to move vehicles rather than corn ethanol. So I think it adds what I'll call a missing piece, or perhaps a more fulsome piece to the analysis than I think we've had so far. And I'll also just note that this is an issue in every case going forward in terms of solar use. I think it's becoming a big issue in the state. I understand, and I've seen it in other cases as well. So land use is going to be front and center in these cases. And I think this piece of information will help inform the commission on it.
Okay. Yeah, I did want to get back to Clean Wisconsin for another follow-up. So, Clean Wisconsin has intervened in at least 2 solar cases so far. I think one of them is that, so on 9815, oh no, I'm sorry, not 9815, it's another one. Well, anyway, I think you cited that it was cited in the reply, I believe, but it's the documents, the evidence that Clean Wisconsin brought to bear in those cases, I thought were relevant and had probative value, particularly because it looked at the land use of the agricultural land use and the impacts on waterways based on runoff and the fertilizer and pesticide application through agriculture. And the premise of the evidence was that removing that land from agriculture would have a beneficial effect for that reason. I thought that was a good contextual provided context that was beneficial to the commission, especially when we're dealing with the environmental effects of the project. But that was actually very, very focused on the particulars of the project. And I'm curious if the same sort of focus in on the land of the project is apparent in the study that Clean Wisconsin is trying to offer in this case.
Your Honor, the study is a statewide analysis. We have considered data requests to the extent the applicant is able to tell us how much land is in corn ethanol right now, which would allow us to get more precise. But generally, the report's intention in this case is to, again, add context to concerns about taking land out of food production. We show that about 1 million or 1/4 of all the corn produced in Wisconsin goes to ethanol. So that speaks directly to intervener Tone's concerns. But to answer your question, the study is not specific to the site, but we are interested in looking at specifics of the project as we proceed.
Okay, so just to cut back to the statute that is relied upon here, it's 196-491D6. The proposed facility will not unreasonably interfere with the orderly land use and development plans for the area involved. So I believe how we've been applying that statute is to look at, I think as Attorney Callisto indicated, zoning and comprehensive land use plans, comparing that to the impact of having a project, any project in that area, and how whether it's compatible or not. I don't believe we've looked before into choices of land use that isn't reflected or apparent in the plans that have been brought to our attention. So how does it relate to land use plans to talk about, generally speaking, the energy output of an acre of solar versus the energy output of an acre, of solar used for transportation versus the energy output used in an acre of corn ethanol?
Your Honor, if I may take a shot at that. I think the the most simple way to frame the arguments that we're hearing that are becoming public from opponents of these projects is that in their view, they are taking prime ag land out of rotation and using it for something other than food. And that is an expressed concern, and it's expressed concern of public comments in this docket. And also an expressed concern of Ms. Tan in her intervention request. And so I think it's relevant to look at how we are using land now. The commission needs to look at that, because if you're to believe the opponents, what we are doing is taking this land and converting it to something that's not useful or less useful. And I think what informs a response to that position is that we are already using land for energy production. And is it better to use this land for energy production by using it for the production of solar energy, or should we continue to grow crops for corn ethanol? So I think it just brings additional insight to the commission, and I'll call it, in my own words, a more candid discussion about how the land in the state is already being used. And is it accurate to say that using it for energy production is wrong or contrary to the best interest of the state?
Mhm.
So I think it provides additional value to that topic. And I'll represent this, and it's my memory, but I know that I've heard at least one commissioner, one of the current commissioners, talk about land use issues. This is an important issue going forward during discussions of records on these projects. So I do think it's an important issue.
Okay. Yeah, so let me hear from others on this. So any opinion of Renew?
I'll try to be brief, because there's a flight being boarded right next to me.
So far, you're okay. We haven't heard any distracting noise, so.
Okay, so I just want to point out that in the record already is a public comment from Larry Nelson, who's the participating landowner in this proceeding. And in his comment, he represents that all of the corn that he grows goes to ethanol production. This is not stated in Mr. Nelson's comment, but Columbia County has, in comparison with other counties, a preponderance of ethanol producing facilities, including two at either end of the project, one in Randolph and one in Cambria. So that there is actually a pretty easy to establish tie between the use of the farmland for energy production, say with electricity, versus energy production that is used for fuel. In neither case is food involved, and they have a tendency that when people, and this might even be true with the decision makers, when they consider agricultural impacts, to frame the conversation on food production and not on other uses for that, for the crops being grown. And in the case of much of the farming population in South Central Wisconsin, ethanol is a very important commodity that the corn is used to create. And I'll end it there. Thank you, Your Honor.
Okay, no, I appreciate that. Intervener Tan, and if you can mute now, thanks. Intervener Tan.
Thank you, Your Honor. I'd like to note that Larry Nelson is not a part of this project. I believe what Mr. Vickerman is referring to is the High Noon docket and not Langdon Mills. He is correct in that there are within about 5 miles of my property 2 ethanol plants, one in Cambria and one in Friesland. And when we're talking about land use, we're also talking about the economic impacts that would happen in a very rural and agricultural based community. not only are there ethanol plants that would possibly have issues moving forward and lose employees, there are also a number of other types of industry around here that rely on the farmland being farmed. Those are also explained in the comprehensive plans, which I think Mr. Callisto referred to, both here in the township of Courtland, the township of Springvale, and Columbia County. So to say that it's just ethanol versus solar is a very narrow-minded way to put it, when it does impact the economics of this community.
Ms. Tan is correct that comment was filed in the High Noon case.
Okay, yeah, I actually do remember reading it, and I'm sad to say I can't remember which document it's in. Any comment from commission staff?
I don't have a comment.
Okay, so so this, I think what intervener Tan raised is really one of my concerns about the study. I guess you probably realize that I do have some concerns about the study. However, I don't have a decision written out on this, so it's still you can still persuade me here. But the problem really is that land use is an issue in this case. However, I think the way the statute is written, it looks towards comparing the use and seeing if it's compatible to existing plans that are concrete plans that we can evaluate. I'm not sure if we need to evaluate the economy of the area and what may potentially be the best use of the land, but also economics is a factor we are not allowed to investigate in a wholesale merchant plant CPCN. So I understand the impetus, the kind of the proactive nature of people wanting to get information to the commission about an issue of concern that people have, especially if they're going to see those concerns in public comments, which we are not going to, scrutinize for the standards, the statutory standards. However, the commission does understands that public comments are public opinion, not information that's been evaluated and scrutinized through the contested case process. So the weight of that evidence is much different. So with that understanding, I don't think if we see public comments to this issue, I don't think it will unduly prejudice the commissioners if there isn't counter comments or counter evidence presented by the parties. However, and so what I don't want to do is I don't want to expand the scope of the case beyond the statutory provisions that we're bound to, because there's issues here that really aren't legally ones that we have a jurisdiction over. And the problem is that looking at land use, especially if we're looking at comparing solar energy, the intrinsic amount of energy in an acre of solar versus that of ethanol, we're looking at changing land, therefore changing land use to a more efficient one, is looking at an economic argument. And then the consequences on the other side of that is, well, you may affect the agricultural economy by taking land out of agricultural use. I don't think the commission has jurisdiction to decide a project based on that either. So it leaves me saying we'll be getting this in terms of public opinion. There are concerns out there in the ether about this issue, but does it meet the requirements of a CPCN statute? Does the commission have jurisdiction to decide a case based on those concerns? I don't think we do. But I think what I'd like to say though is there may be use at seeing the particular properties and how that land use may be affected by solar application of solar rather than agricultural use. And then that comparison can be applied to the comprehensive land use development plans, and to see if the change in use is compatible with those plans. For example, if the plans state that we want to promote agricultural activity and we are pro renewable resources, then you can state that there's compatibility, or there's at least an argument that the solar use is compatible with a comprehensive land use plan. But if I go back to what Clean Wisconsin has introduced in the past, the particular looking at impacts of agriculture and the reduction of those impacts on the environment in the actual area of the project is useful. I'm not so sure. I'm pretty sure that looking at the statewide use of land on a per acre basis, solar versus ethanol, it just raises more questions than it answers, and just derails the commission's investigation, sets it beyond the scope of what it's allowed to look at in a wholesale merchant plant CPCN. I was trying to look at these statutes and trying to find out where that comparison would fit. And really the only place I could find is that it's economic, it's an alternative source of supply. So those are both not applicable in this case. And I don't know if they would be anyway in any CPCN, but this is a supply of energy, and you're saying, well, let's do solar instead of ethanol. I think that goes beyond the scope of this proceeding. So,
Your Honor, may I be heard just briefly on this?
yeah, sure.
So I know you've been referring to the 196-491 3D3 standard, which talks about, and I'm looking at it right now, it talks about is in the public interest, including economic factors. But then, of course, there's the exception that says you can't use economic factors for wholesale merchant plants. And as you've noted, of course, this is a wholesale merchant plant. I think that provision has historically, both as a matter of commission interpretation and as a matter of evidentiary or evidence that's allowed in these cases, it's been construed to the economic impact on ratepayers. If you look at these cases, all the merchant cases talk about the economic impacts to the community. And indeed, multiple cases put in economic impact studies, as we have done in this case. So there is a wealth of precedent and evidence in other cases that shows the great economic value of these projects, or the economic impact of these projects to the community. And I think the topic that we're talking about here, the study we're talking about, is really no different. In fact, Ms. Tan just raised it herself, right? She clearly has concerns about switching the use of this land to something other than ag. It's going to be in this case. I mean, I recognize that you appear to be leaning towards keeping this report out, but the idea of the economic impact of changing this land to solar is going to be a front and center issue in the case. And I say respectfully, it has been for all the cases I've been involved with. I just think this adds some more value to that conversation. I don't think the commission should shy away from land use issues. And indeed, it's going to get a ton of attention going forward. Appropriately so, I think.
Okay. Yeah, so I can explain some background here, and that is I actually was considering and am considering eliminating the question completely, because it seems to go beyond the scope of CPCN proceeding. But yeah, I think, well, I'm still leaning towards, and I was going to in terms of the choice of land use, basically limit that to looking at the comparing the solar facility with the development plans and zoning, as it's contemplated in paragraph 6. But the economic studies that are put in place does elucidate the payments in lieu of taxes and other benefits that accrue from these projects to the local community, and issues of job creation for construction and for ongoing operation. Those are issues that we collect in these cases. I don't know if we necessarily make decisions based on that, on those factors, but
Your Honor, just one more point on this. If you look at the way the statute's constructed, 491(3)(d), it's not limited to the enumerated sections, right? The commission has to act in the public interest, and it is, while it's acting in a judicial capacity, it has to follow obviously the law. Limiting this kind of testimony and limiting sort of the economic testimony that's come in prior merchant cases, and indeed in this one, I think is inconsistent with the statute, which allows evidence to come in to help the commission make a decision that's in the public interest. It has to make findings as to those other factors, but that doesn't preclude it from looking at other testimony and evidence that will help it make a public interest finding.
You're starting to sound like an intervener. That's an interesting take on that section. I don't think I've heard an applicant argue in that way before, for a wholesale merchant plant anyway. And I mean, there's that, I hope, doesn't mean that you could, does it mean that you can then blow a hole through alternative sources of supply and economics and other prohibited factors for a wholesale merchant plant?
No, I don't. I think some of those exceptions or some of those exclusions to wholesale merchant plants have a much more, I'll call it, traditional and sort of narrow limitation. But this idea of economics is the vein that runs throughout these projects. And it's a key issue of importance to the local community. And I'm not just talking about the payments that come, I'm talking about the very things that Ms. Tan is raising herself. You know, what is the impact of this project to the local community? I'm not suggesting that in any way that those concerns are not valid. And I think it's appropriate for the commission to consider the impact of a 1,000-acre project on the local community in as expansive a ways the commission wants to. I think the commission is learning about these projects. We're now, I think, on something around 20 of them in the state in various ways. And we're learning more about the impacts. I concede that. And my client is quite on top of that and aware of it. And so any information that helps the commission better understand the impact to the local community, fairly understand them, I think is appropriate as a basis to be in the case.
Okay.
And I think this report is part of that.
All right. Anyone else like to speak on this?
Your Honor, just briefly, in the same provision that we were just discussing, environmental factors are a consideration that can be considered. And, that goes to the different impacts of using corn for ethanol and, of course, using the land for solar. So I agree with Attorney Callisto that, these issues have been raised by an intervener already. And I would just like to echo his comments about, what is before the commission on this.
Okay. All right. So,
Your Honor,
yeah, go ahead.
If I may apologize, I'm Andrew Kell with Renew Wisconsin. With my colleague, Mr. Vickerman, is boarded a plane. I don't have any further legal analysis to provide for you this afternoon. However, similar along the lines of the report that Clean Wisconsin would like to submit, Renew Wisconsin does have a solar and agricultural land use fact sheet. We're in the process of updating that right now, and it's informed by analysis that results from our zero carbon study, looking at solar penetration by the year 2050, how much solar will be potentially developed in the state of Wisconsin, how much land will be required for solar by that year in the future. So your decision today would probably impact our ability to submit evidence in this case and other solar construction cases in the future as well. So just wanted to let you know that in terms of exhibits we may be submitting in the future. And I would just agree with several of the applicant and party pieces of information they share with you, that this is going to be a big contextual issue that will likely drive commissioners' decisions, at least in the context of their awareness of the impact to agricultural land use and to the economy of Wisconsin going forward.
Okay, thanks. Okay, well, I think I'm going to go back to my concern, essentially, that we're looking at apples and oranges here, and that the study is a statewide study that doesn't seem to be applicable, or there's no evidence that it's applicable to the project area directly. So at this point, I believe that the study is irrelevant and has no probative value. It would confuse the record to put up as one sawhorse to climb that you have this statewide study and it's comparing an acre of solar versus an acre of corn ethanol and its energy output. To try to connect that to this case, I think raises more questions than it answers. So in terms of the study as it exists now, I think that it lacks probative value, and to the extent it has any probative value, it increases the burden upon this process and upon other parties that goes far beyond the benefits. To be able to rebut and vet that study, I think derails the process and takes us down a path that it's not beneficial to us. However, saying that, I think that if there is a direct connection between the conclusions of the study and the land in play in this proceeding, and that tie can be made, I may have a different opinion of that. So if there's a way to present this analysis in the project area, there may have a different opinion of that. But the other concern I have underlying all of this is that the comparison between solar and ethanol production really is, to me, seems like, I don't know, what's the red herring? There's no relationship to know that that there will be that consequence based on this project, that corn ethanol will be converted into land devoted to corn ethanol will be diverted to solar that's used for transportation. So that's kind of one of the main hurdles I have. Now I know we're just trying to give context to the issue and the general concerns that people have raised. But I think the concerns that people have raised on the intervener side are particular to the area in question. It's not fair to then bring in sort of a generalized view of Wisconsin as a whole without relating it back to the land that's in question. So let's not derail the case and have apples and oranges comparisons. If a comparison could be brought to bear that somehow can show that there's a relationship between the benefits of solar and I guess it's transportation electrification that somehow comes out of this project versus corn ethanol that I suppose is ongoing at the current time in this area, that seems relevant, probative, possibly. But the study that's generalized and doesn't relate to this project directly just would divert our attention to the important issues in the case. So having said that, I would reject the offer of the study itself into the record. Having said that, I still have the late intervention standards to address in terms of the request to intervene. So let's get through that. In terms of intervention out of time, when determining a request to intervene out of time, the commission may consider all of the following factors. It's 1, whether the requester had good cause for failing to file the request within the prescribed time. 2, whether any disruption of the proceeding or docket may result from permitting intervention. 3, if any prejudice to or additional burdens upon the existing parties may result from permitting intervention. And that's Wisconsin Administrative Code, Section PSC 2.214A. So I wanted to ask and set up a question here. So in terms of the good cause issue, in docket 9815 CE 100, the commission granted Clean Wisconsin's timely and undisputed request to intervene. Thereafter, Clean Wisconsin participated in no substantive way, i.e. it filed no evidence or argument. During this, neither this tribunal, commission staff, nor any other party questioned Clean Wisconsin's lack of participation. Given this experience, I'd like Clean Wisconsin to explain its decision to withhold from filing the request until the study was complete, and thereby causing it to file the request late by 21 days.
Yes, Your Honor. As you know, Clean Wisconsin regularly intervenes in commission proceedings where the interests of our members may be affected. Emphasis on the may. Sometimes it's unclear in the beginning of a proceeding what issues will be raised. In those cases, Clean Wisconsin sometimes intervenes so that we can engage on issues that may not be apparent until data requests, responses, or testimony, for example, bring those issues to light. In the docket you referred to, 9815 CE 100, we did not feel that there were any outstanding issues that needed to be addressed in that docket, so we opted not to file testimony or briefing. Though we sometimes intervene without knowing to what level we would participate, issues of internal capacity and a desire to promote efficient disposition of cases before the commission result in us not just intervening in every case that comes up. In this case, based on the issues that we've been talking about at length, we decided that including the study would help promote the proper disposition. I'm not really clear where that leaves us with your proactive prohibition of getting the study in as it exists. So.
Okay. So I was wondering, so it's basically staff or the organization's resources that prevented you from filing on time.
Yeah, I mean, we try our best to pay attention to what issues are, being discussed either in commission, or applications or early public comments, that kind of thing, or, information from outside of PSC proceedings that might indicate issues that may come up. But yeah, I mean, we don't have the resources to be intervened in every single case. And, we try to use our time efficiently. And that's one of the reasons why we thought coming in on this case when we did would be beneficial, because we had a study we wanted to introduce.
So, because I think in your reply talked about getting the study completed and published as being the reason why it wasn't filed, why intervention wasn't filed early, or at least on time. And I guess my question was, well, if you can file for intervention in a case where you're not sure you have anything to submit, why wait in this case till the study is published to file a request to intervene?
I guess my response, that every case is different. There's different issues brought up, like I said, in public comment or from the communities where the projects are cited. We weren't intending, we wanted to intervene in this case with the ethanol study, but didn't want to intervene if we didn't know that we were going to have the study to present.
Okay.
And that was a decision about our capacity to participate.
Okay. So this study isn't peer reviewed, is it?
No, it wasn't published in a peer-reviewed journal. It wasn't intended to be. While we believe it's valuable information, scientific journals typically publish work that advances the science and are, broadly applicable to a journal's audience. This study in particular summarizes existing peer-reviewed literature on the topic, as well as some non-peer-reviewed analyses. And it took that information and applied it to the narrow Wisconsin-specific context. We did this by substituting Wisconsin-specific values for various components of the previously reported analyses, but we aren't breaking any new methodological ground that would merit publication in a journal. All the calculations are shown, cited, described in the appendix for full transparency, and the lead author of the study, Dr. Paul Matheson, would be the witness sponsoring the study as an exhibit.
Okay. Okay, well, I guess I'm not completely clear on the facts as to why the request was filed late. So I'm not going to declare that there was or was not good cause on this because we've already denied intervention by right. And the in terms of the permissive intervention, I will not be accepting the study at this time. However, I can grant permissive intervention for Clean Wisconsin and leave open the opportunity to present information with particular application to the project area. And so I'll refer back to the prior solar dockets where the information was particular to, I can't remember if it was on at least on a county-wide basis. I'm not sure if it actually looked at the exact property. Closer you get to the property, the better. But I think we need to tie whatever assertions are being made in terms of land use comparisons to the project area. So Clean Wisconsin can intervene on those grounds. Let me also be clear that there may be a slight, it may be sort of a historical anomaly here that, when requests are filed, people tend to use the phrase full party status or limited party status, that there really is no such thing. I don't grant intervention on some limited purpose. Person's either a party or is not a party, and all the rights and responsibility of being a party apply to all parties. So I'm not limiting Clean Wisconsin's participation to land use comparisons, but the request that Clean Wisconsin made was particularly only for filing the study. So I'm rejecting the filing of the study, but I'm not rejecting the potential for Clean Wisconsin to participate as a party if it can provide probative information of probative value. So I also want to mention that, yes, I think there may be some confusion about saying, oh, you're putting the cart before the horse because you're ruling on evidence before the hearing. But actually, typically, well, what's the first thing we do in a pre-hearing conference is we discuss the scope of the issues. And I think that's really what we're doing. I think if typically we would see when parties come to a pre-hearing conference with solar projects and CPCN projects, we have our standard issue, but that doesn't mean that doesn't preclude a party from saying, but I believe a party is going to be looking at this in a novel way or a way that goes outside of the scope of the case, and I would like that noted, and the issue limited or further explained, so to keep the case on track in this particular circumstance. So now I was surprised to hear that everyone agrees that well, not everyone, but there is sort of agreement of more expansive interpretation of economics, and some of the more limiting factors in a wholesale merchant plant CPCN. However, I think that pre-hearing is the appropriate time to set parameters to the issues, and if we have to be more specific in a CPCN to say there's certain issues cannot be raised because because in these circumstances they will go beyond the scope of the case, that this is an appropriate time to do so before we invest time and energy in producing evidence. So I think that's consistent with our practice to say that we're not letting in certain things as a matter of law because in this preliminary venue, because we know that we won't be able to accept it later. So I wanted to just make sure everyone understood why this is happening now. It's pretty hard to track a case and catch things as they're coming in, making sure we can get a decision issued before the next round of testimony. We've seen that occur in past cases where the information is coming in on a very broad scope. The record was tremendously large in what ended up being information that the commission did not use to make its decision. And to the extent that the pre-hearing conference process can be used to keep the case on track, I want to do that. So like I said, Clean Wisconsin can be permissive intervener, but the evidence I would expect to see coming in should be particular to the project area, the local economy, local land use practices, and like we were saying, we're looking for whether it's compatible land use with the project is compatible with land use and development plans, and also to some extent, I suppose, an economic argument. I don't know if I'll hear objections to that or not, given the state of the parties today, but we'll be careful not to expand the scope of the case beyond the commission's jurisdiction. So any other comments?
Your Honor, I guess from a process perspective, 2 questions. Are you going to memorialize your ruling today in a written order?
No, I think we're going to let it stand on the record.
Okay, then, and maybe you can answer this, maybe you can't. If anybody decides they'd like to take an interlocutory appeal of this, are we considering this a ruling during a hearing?
Yes.
Where it is? Okay.
That's the only way to think of it, I believe.
Okay.
But given that, I suppose the commission can take this up on its own motion, which it has done in the past.
Understood. Thank you.
Yep. Okay, anything else?
Not for me, Your Honor. Thank you.
All right, thanks very much. We're adjourned.